Supreme Court of India Baba Natarajan Prasad vs. M. Revathi decided on July 15, 2024 SEC Online SC 1710. Facts of the case. The complaint was filed by the husband under Section 200 CRPC for offense punishable under Section 494 IPC with the allegations that his wife, i.e. first accused, during subsistence nuptial bond, married with the second accused, from wedlock of the first accused with the second accused a child was born. Trial court acquitted the parents, i.e. accused numbers 3 and 4, and convicted the first and second accused. Under Section 494 IPC, ASJ acquitted both the accused. High Court imposed only fleabite, imprisonment till the rising of the court, sentence for the conviction of the respondent accused. Findings of the court. The sole question surviving for consideration is whether the High Court was right in not restoring the sentence imposed for the conviction under Section 494 IPC by the trial court. A reading of Sections 494 and 495 IPC would reveal that the legislature viewed the offense of bigamy as a serious offense. Though no minimum sentence is prescribed under Section 494 IPC, the maximum sentence of imprisonment prescribed thereunder for a conviction thereunder is 7 years of imprisonment of either description. It is also to be noted that the said offense is compoundable only by the husband or wife of the person so marrying with the permission of the court. The same offense under Section 494 IPC, with concealment of former marriage from person with whom subsequent marriage is contracted, would visit the offender with imprisonment of either description for a term which may extend to 10 years and with fine. This offense, which is an aggravated form of bigamy, is non-compoundable. When once it is found that an offense under Section 494 IPC is a serious offense, we have no option but to hold that imposition of sentence of imprisonment till the rising of the court, upon conviction for an offense under Section 494 IPC, on them was unconscionably lenient or a fleabite sentence. We are of the considered view that the trial court had virtually struck a balance in fixing the term of 1 year as the corporeal sentence. But then, taking note of the fact that the said child is now aged only about 6 years and the sentence for the conviction under Section 494 IPC can be of both descriptions, we think it appropriate to use our judicial discretion to modify the sentence imposed under the impugned judgment. Accordingly, we modify the term of the sentence awarded to accused numbers 1 and 2 for the conviction under Section 494 IPC to 6 months each, making the nature of the sentence as simple imprisonment for the said period. We further modify the fine imposed by reducing the same from 20,000 rupees each to 2,000 rupees each, as originally awarded by the trial court. The appeals are allowed as above.